Contract and its kinds. Meaning of law. The law is a set of rules and regulations used to govern a society. It is enforced by the state to regulate the business, protect the rights of people, and ensure justice in the society. It explains the rights and obligations which can be enforced and accord. The law is necessary to maintain peace and order in the society. In the absence of law, no person will recognize the rights of others. Business law. Business law is also known as commercial law and mercantile law. It is a branch of law which regulates the trade and commerce. It deals with the rights and obligations arising out of business transaction. Business law. British business law. Pakistan inherited its legal system from the British. The pre-partition laws and legal decisions are still followed. Pakistan adopted the Contract Act 1872, 1872 Sale of Goods Act 1930, Partnership Act 1932, 1932 and some laws were amended according to the needs. Pakistani law. Pakistan passed new laws such as the Companies Act 2017, Limited Liability Partnership Act 2017, and various labor laws. Judicial decision. The judicial decision of British, Indian, and Pakistani courts are a source of law. The past judicial decisions are followed by the courts while deciding similar cases where the law is silent. The courts decide according to the principle of equity and justice. Custom and usage. The customs, a particular trade, are an important source of business law. These customs and usages uh, the members of a trade in their dealings with each other. The Act 1872 provides that nothing shall affect any usage or custom of trade. Law of contract. The law relating to contracts in Pakistan is contained in the Contract Act 1872. It applies to the whole of Pakistan. It came into force on 1st September. Eighteen 1872. It deals with the general number first, the general principle of all types of contracts, and the contracts. Here we now we define the contract. Any agreement or promise enforceable at law is a contract, or a contract is an agreement creating and defining obligation between the parties. Section 2. An agreement enforceable by law is a contract. The definition shows that for a contract there must be an agreement between the parties and the agreement must be enforceable by law. Agreement. Section 2 defines agreement as every promise and every set of promises for forming the consideration for each other is an agreement. It means that every promise is an agreement if it forms a consideration of both parties. If a promise forms no consideration for both parties, it cannot become an agreement. Promise. Under the promise, it defines promise as when the person to whom the proposal is made signifies has essence thereto. The proposal is said to be accepted. A proposal, when accepted, becomes a promise. It means that when one person makes a proposal offer to another person, and when it is accepted by the other person, it becomes a promise. Proposal defines proposal as when one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assist to the obtaining of that other to such act or absentees. He is said to make a proposal. It means that when one person shows his willingness to do or not to do anything in order to get the consent of other person, it is called a proposal. A proposal is also called an offer. Example, here we take the examples that Ahmad offers to sell his car to Barina for 8 lakhs. B accepts the offer, it becomes a promise. Enforceable by law. An agreement is enforceable by law if it creates legal obligation between the parties. Thus, the term agreement is wider than a contract. All contracts are agreements, but all agreements are not contracts. There are two types of agreement. Social agreement. A social agreement is not enforceable by law because it does not create legal obligation because between the parties. In a social in a social agreement, the parties do not want to create legal relations. Legal agreement. Illegal agreement is enforceable by law because it creates legal obligation between the parties. In a legal agreement, the parties want to create legal relation. In a business agreement, it is presumed that the parties want to create legal obligation. Here we take the examples that Ahmad invites Ali to a dinner. Ali accepts the invitation but does not to attend. Oh, so Ali cannot sue the Ahmad for damages. It is a social agreement. Now I'm going to tell you about the essential of a valid contract. A valid contract is enforceable by law. In a valid contract, all the parties are legally bound to perform the contract. In order to enforceable, an agreement must possess the essential of a valid contract given in section 10. Offer and acceptance. An offer is the starting point of a contract. In order to perform an agreement, there must be an offer by one party and an acceptance of that offer by the other party. Here we take the examples of Ahmad offers to sell his cycle to Bahina for 4,000. It is an offer. If B accepts the offers, there is an acceptance. The next one is legal obligation. The parties to an agreement must create legal obligation. It means that if one party does not fulfill his promise, he shall liable for breach of contract. Musa, sorry, it is presumed in a business agreement that the parties want to create legal obligation. HB take the example. C offers to sell his watch to B. Per 1800, B agrees to buy it as contract as it creates legal obligation. Uh, the next one example is a husband promised to pay his wife an allowance of $30 every month. Later they separated and the husband refused to pay. The wife sued him that the wife could not recover the amount as the parties did not want to create legal obligation. La- and and the next one is lawful consideration. The consideration means something in return. The agreement must be supported by a lawful consideration on both sides. The consideration is the price paid by one party for the primacy of the other party. An agreement is enforceable only when both the parties give and receive something. The something given or received is called consideration. Here we take the example. C agrees to sell his house to B for 80 lakhs. The 80 lakhs is the consideration for C and the house is the consideration for B. The next one is capacity of parties. An agreement is enforceable if it is made by parties who are competent to contract. In order to be competent to contract, it is essential that the parties must be of the age of majority of sound mind and not disqualified for contracting by law. An agreement within with an impatient person is not a valid contract. Example: if a person of unsound mind agrees to sell his house to N for 20 lakhs, it is not a valid contract because M is not a competent to contract. Pre-consent. For a valid contract, it is essential that the consent of parties must be free. The consent is free when it is not obtained by coercion. coercion. Undue influence, fraud, misrepresentation, or mistake. If the consent of either of the parties is not free, the agreement cannot become a contract. Example: C companies B to enter into a contract at gunpoint. It is not valid as the consent B is not free. Lawful object. The agreement must be made for a lawful object. The object of an agreement is lawful if it is not fraud, illegal, immoral, abuse to public policy, or involves injury to a person or property of another. Every agreement with the unlawful object or consideration is legal and void. Example: C promises to pay $5,000 to B. If B beats D, the agreement is illegal as its object is unlawful. The next one is writing and registration. A contract may be oral or in writing. However, if the contract is in writing, it is easy to prove in the court. Where it is necessary that a particular contract must be in writing, signed, stamped, attested by the witnesses, and registered. It must fulfill all the requirements to become a valid contract. Certainty of terms. Section 29 status. Agreement, the meaning of which is not certain to capable of being made certain or void. The terms of an agreement must be clear, complete, and certain. If the terms are uncertain, the agreement is void. Example: she promises to sell these 20 books to be without specifying their titles. The agreement is void because if the terms are not clear. The next one is possibility of performance. A valid contract must be capable of being performed. An agreement to perform an enforceable act is void. If the act is legally or physically impossible to perform, the agreement cannot be enforced by law. Example: she agrees to discover a treasure by magic. The agreement is not enforceable by law. The next one is expressly declared void. The agreement must not be one of those agreements which have been expressly declared void by the law. So it's enough for today. Hope you will be understand, and if you have any question, so you can ask easily in the comments section.